I'm Locke Meredith. I'd like to invite you to join me on the next Legal Lines where our guest is Judge Duke Welch. He's a judge for the First Circuit Court of Appeals, and the judge is going to talk to us about the difference between the trial court and how it functions, and the appellate courts and how they function. He's going to also talk to us about a good idea, and that's putting video cameras into the courtrooms so we, the public, can watch how the court system and judicial system works. So join us on the next Legal Lines with Judge Duke Welch. Hello, welcome to Legal Lines. I'm Locke Meredith. I'm very pleased to have on the show Judge Duke Welch. He's a judge for the First Circuit Court of Appeals. And Duke, thank you so much for being on the show.
My pleasure.
It's good to have you back on. You, as we discussed before, were the very first guest I had probably over 10 years ago.
You know what, I had the opportunity to look at our first interview and
Bet we looked a little better.
Well, actually, we had a little less gray and me a little more hair.
Yeah, well, me too. I can promise you. Tell the folks a little bit about yourself. Just, educational background, family history, so they can kind of see where you're coming from.
Locke, I'm born in Baton Rouge, grew up in Baker, graduated from Baker High School, went down and tried to, during Vietnam, and tried to join the Marines, but I had a football injury, so I ended up going in the Air Force for 5.5 years, and loved that, and finished my undergraduate degree at the University of Maryland in business management, and got accepted to LSU Law School, and got out of there.
The rest is history, huh?
The rest is kind of history.
Well, you also a politician in the sense that you were on the Metro Council.
Well, the day I graduated from law school, I've been in elective office for 30 years now. The day I graduated from law school, I got elected to the Baker City Council and served there for 8 years. And then when Mayor McHugh became mayor, I ran and took his position on the Metro Council for 6.5 years, and then ran for 19th Judicial District Court, and when they created the new seat back in 1995, and have been a judge for the last 16 years.
And boy, has the city in Baker grown.
Ooh, the changes in Baton Rouge, it's phenomenal.
Boy, has the city in Baker grown.
Ooh, the changes in Baton Rouge, it's phenomenal, the whole parish.
We had District Attorney Hillary Moore in just a little while ago, and we were talking about how fast, and it's the fastest growing area in Louisiana, and of course crime's gone up and litigation's gone up, and you've been there for all of it.
Oh, I certainly have, and things have changed so much over time, but some things change, some things don't. But the crime issue in our parish is a national issue, and let me tell you what, Locke, about 90% of that is drugs, and until we can get and wise up and figure out how to deal with that, we have, even when we lock people up, we have a 70% recidivism rate. So even when we locking people up, they're still addicted to drugs, and when they go back out on the street,
it's a horrible, vicious cycle.
It's a terrible cycle, and we're seeing them back in the system, and we just got to be smart and figure out some way to do that.
And of course, he's seeing it on the front lines. You've seen it when you were a trial judge, and of course now you're seeing it on the appellate level.
Well, the first 2 years when I was a district court judge, I did nothing but criminal, which was everything from a traffic ticket to I did capital, death penalty cases. So, I've seen it firsthand as well, and seen a lot of the same people coming back through, and it's really breaks your heart.
What would you say based on your experience? You've been there a long time. What needs to change?
We have got to break the addiction cycle, and that is so hard to do because you have the poverty element intertwined with the addictive nature. And our whole system of economics is based upon the Keynesian theory that we will all do what's in our best interest economically. So you'll go to school, you'll get a job, you'll work hard and do that. But when you get addicted,
that model breaks down, doesn't it?
The complete economic system breaks down because the primary goal is not making money. The primary goal in your mind becomes the drug or the addiction.
Well, your son Trey is on the Metro Council, following in his dad's footsteps.
Well, actually, he's following in his mom, because I was on the Metro Council for 6 years. My wife was on it for 6 years, and so he's
That's
sort of
right.
he's
It's
been
a
on
family
it now.
tradition.
I don't know, but
Gotta happen. Well, what would you say, just kind of a comprehensive view, because you have sat in that seat before and your family has been there and is still there. From a political legislative point of view, how would you deal with it? Because really the legal system, there's not much they're going to do differently.
Well, what's so bad about the legal system, Locke, is it's after the fact.
Right.
It's
not proactive.
It's not proactive. We're reactive. When you do something and there's a law broken, and let me tell you what, I mean.
And there's mandatory sentencing, isn't there?
Exactly. In many cases, there's mandatory sentencing. And we in Louisiana have the highest incarceration rate of any state in the country.
Number one, Judge.
And the United States is the highest incarceration rate of any nation in the world. So, I mean, we've got to be smarter about what we do with people who break the law and how we get them back into the fold, so to speak.
In my head, there's like three groups. There's the kids that are susceptible to that world, and they're at risk, and we can try and deal with them. We got the folks who are in the system, and I guess we can try and educate them and give them skill sets that once they get out of the prisons, they don't have to go back to it. And then there's the group that has gotten out of the prison system. Is there some type of follow-up? I mean, what do you do with that?
Well, I mean, you have, there's systems upon systems upon systems, and I hate to say this, but in the circumstances we're in, it just doesn't seem to be working very well.
Meaning money's not there to do it?
No, it's millions and millions of dollars that are put into incarceration, into rehabs, into all types of systems and skill sets and labor and job training, and all those funds are there to try to give people an alternative. But once an individual turns and their mind becomes addicted, at that point in time, it's out the window, and we have to, and the programs that we have now, none of them have shown to be very effective in dealing with that.
It almost sounds like it's going to require some type of medical or psychological, psychiatric component.
Well, I'm going to tell you what, if you and I had the answer, we would do a lot of good.
Wow. Judge, let's talk about the Ends of Court, because not many folks know what it is. You're the president of the Ends of Court here in Baton Rouge, recently received from the United States Supreme Court Justice Clarence Thomas the award. Explain to the folks what it is.
Well, the Ends of Court came from England, and it was a group of lawyers that would get together and they would talk about professionalism, they would talk about excellence in the practice of law, and they would talk about ethics and how they would make the community better. So that the Ends of Court concept has come to this country, and there's about 360 ends in the United States. And we have 3 in Baton Rouge, and I'm very proud to be the president of the Dean Henry George McMahon.
That's the first one, isn't it?
It's yes.
I remember that.
And we have we were selected for the Platinum Award of Excellence last year, and I did receive our award for our whole end. We have some tremendous people involved in our end, and we're one of the top 15 ends in the whole United States. So,
and it brings together lawyers and judges, both on the state and federal level,
yes,
and local politicians.
Anyone who's a lawyer can be a member of it. And then we also bring in the law students. So we try to get them early and get them involved in
Fantastic
our
program. Well, we'll
yes,
continue this on the next Legal Lines. I'm Locke Meredith. Locke Meredith with Judge Duke Welch. We'll be right back. Welcome back to Legal Lines. Again, I'm very pleased to have on the show Judge Duke Welch. He is a judge on the First Circuit Court of Appeal. Again, Judge, thanks for being on the show.
So nice to be with you today.
Let's talk about the difference between a trial court judge, an appellate court judge, and a Supreme Court judge, if you don't mind.
No, I don't mind at all.
You've been a trial court judge for how many years?
I was a trial court judge for 10 years. I've been on the Court of Appeal for 6 years.
And that's
now.
a 10-year term for the
Correct.
appellate court.
And I was a lawyer for 13 years.
Okay.
So I've had, in the legal profession, I've had 3 different careers.
Well, let's talk about the job duties, so to speak, of a trial judge.
Well, a trial judge is a very, very important job, because the trial judge, when you go before, like for instance, the 19th Judicial, whether it's traffic court, the trial judge makes a determination of who's telling the truth. And oftentimes you never have a dispute unless there is a factual difference.
Right.
It's like, was the light red or was it green, or, did you do this or didn't you do that? That kind of thing, or, were you speeding or not speeding? Those kind of things. So the trial judge is the one who listens to everything and decides who he or she believes. So that is a very, very important job, and it takes a lot of skill.
And it's on the front line.
And it's on the front line, and it is the closest to the people. And that judge is primarily focusing on the justice of the case that's before him or her. In other words,
That one case,
that judge is trying to make a determination based upon the facts as they find them and the law that's applicable. And so that is a very, very important function.
and very broad discretion given to the trial court judge or the jury in that act.
Absolutely. The judge can find the facts, or the jury can determine, if it's a jury trial, who they believe and who they don't believe. But once that determination is made, then that becomes the law pretty much. Now, there is, in Louisiana, is only one of the states where you have appellate review of facts, but that is so very limited. So once generally the trial judge makes up their mind where the truth lies, that becomes the law.
So, for example, if the judge says, I believe witness A, I do not believe witness B,
That's
the
right.
appellate court is not going to reverse that.
The appellate court is not going to reverse that at all, except if there were 30 people that said witness A didn't have the green light and witness B had it. Then the trial judge said, I believe witness B. Then the appellate court may look at that and can look at that. And there's been a lot of debate about whether that should be or shouldn't be, but it is the fact. We can do that.
And as you mentioned, most states rather don't permit that appellate court
Most
that
states
power.
do not allow appellate review of facts.
But the standard of review for that determination by the appellate court is called what? What do they?
That's manifest error. I mean,
Like you said, it takes 30 people saying.
Yeah, it's going to take a whole lot over here as opposed to there to overrule that trial judge.
All right. So basically, the trial jury is going to determine what the facts were.
Correct.
Apply the law to the facts.
The judge is going to apply the law to those facts.
And then what happens?
And then there becomes a judgment. And that judgment decrees the rights and obligations and duties between the parties in that case.
Now, there's what's called a record.
Correct.
Explain to the folks what that is.
A record is made when you walk in the court and somebody swears in. There's a court reporter up there that transcribes everything. And so a record is made of everything that's said in the courtroom, and also a record is made of all the exhibits that are introduced, and that becomes the record of a case.
And those records could be photographs, they could be medical records, they could be any number of things.
Tires, exhibits, whatever is introduced into the record and the trial judge allows into the record, that becomes the record along with the transcript of what was said.
And the reason it comes in is because that's what the judge looked at to help decide what the facts were.
Exactly right. Now, there may be some things that the judge excluded. Those are proffered.
And explain to the folks
lawyer,
what that means.
It means it's not an official part of the record, but one of the attorneys for some reason or the other believes it should be admitted. The trial judge has disallowed it, but will allow it to the Court of Appeal to look at it, but it is not part of the judge's fact finding.
And so if it's a jury trial, the jury never even sees the
jury
proffered
never
document
sees the
or
profit
evidence.
document.
Okay.
Correct.
And then the reason the record is so important is why?
The reason why the record is important is because if either party, and sometimes both parties, don't like what happens at the trial court level, they have a right to appeal it to a court of appeal. And that's where in Louisiana we have 5 courts of appeal.
And so, kind of to summarize it in my simple head, I kind of think of it like the trial court is where you throw everything in the box. You'll call it the record box, whether it's tires or records or whatever. And that's what was considered by the trial court.
Correct.
And then when the parties, either one or both, don't like it, that box is shipped over to the First Circuit or the Court of Appeal.
Exactly right. Everything is transcribed by the court reporter. The evidence is accumulated, and it is then delivered to the courthouse.
Now, before the parties appeal a decision they don't like to the appellate court, there's actually a couple of motions they can file to try and get the judge to do something different, right?
Absolutely right. There's they can ask the judge to entertain a motion for a new trial.
Which means what?
A new trial means, Judge, this is just wrong. And we want you to look at it because you were here, for example, in a jury trial. You were here, you saw the evidence, and there's no way that these jurors could or should have come up with this, and we want you to look at it. Or if the judge tried it, then Judge, listen, we think you might have been having a bad day, but you really ought to, won't you look at this one more time?
Right.
And the judge does have the discretion to do that. Then we have the judgment notwithstanding the verdict, which is there's no way any sane people could have come up with this verdict, and therefore we want you to overturn it.
And then there would be one last motion that would deal with the amount of damages that would be awarded, which could be for a reduction or an increase.
Could be an increase, it's remititure to take away damages, or an additure, which would add damages.
Okay. And bottom line is, if either party or both don't like what the trial court finds and the judgment rendered, they appeal it, and they have certain delays. Explain that to the folks.
If, for example, an individual, let's say, has a judgment and a certain amount of money is awarded, let's say $50,000, and the judgment is party A, you pay party B $50,000. You can file 2 types of appeal. The first type is called a suspensive appeal, and it has to be filed within 30 days of the new trial delays. And that is where you can't collect on that until it's reviewed by the Court of Appeal.
So in essence, the impact of the judgment is suspended. You can't act on it.
Exactly, suspensive appeal. Then there's another type of appeal called a devaluative appeal, which really means that the judgment stands, but the Court of Appeal will look at it anyway.
And so if somebody got a judgment for damages, they could actually go out and start seizing
They
assets.
could actually, once the suspensive appeal delays ran out, they could go out and start collecting on that.
All right, we'll continue this on the next Legal Lines. This is Locke Meredith with Judge Duke Welch. We'll be right back. Welcome back to Legal Lines. I'm Locke Meredith, and again, very pleased to have on the show today Judge Duke Welch. He is a First Circuit Court of Appeal judge. Again, thanks for being on the show.
Love being here with you a lot.
We've talked about the trial court and basically how it works.
Yes.
We've talked about that you create this box, which is called the record, which is all the evidence, and it's
Yes.
shipped over to the appellate court.
Correct.
What does the appellate court do with it?
Okay, what the appellate court does is requires the lawyers to file briefs. In other words, the lawyer that lost is called the appellant, and they explain to us why they shouldn't have lost, and they do that in a brief. Then the other side answers that. They're called the appellee, and the other side answers it and files a brief and says what happened below was just fine. So the job of the appellate court, we sit in panels of 3 judges, at minimum 3 judges, sometimes 5, sometimes 7, and then sometimes 12. But we will review what happened below, and what we're looking for is not so much factual issues, but we're looking for mistakes of law. Was there a mistake of law made at the lower level that caused the trial to be unfair or unjust?
And of course, there's no witnesses or any new introduction of documents or tires or anything like that. If it's not in the box at the trial court, it's not getting in the box.
It's not getting in the box at the appellate record, and it's a cold record. In other words, we're reading the testimony. We're not looking at the people, and we're not deciding who was telling the truth. We're just looking to see what was said to the trial court.
And typically there will be what's called the oral argument. Explain to
Correct.
the folks what that is.
If a lawyer chooses to have oral argument and they file their brief timely, they have the right to come in front of a panel, the panel that their case is assigned to at the Court of Appeal, and argue about the points of law that they think where the mistakes were made, or the answer to that, which is the Opar Harvey, the other side of the story, and why it was correct.
Of course, the judges kind of get involved, don't they, sometimes?
Well, the judges immediately, most of them that I know and been on panels with, the lawyers just don't get to read their briefs. They're asked specific questions about the cases they cited, about the law that was applied, exactly what relief they're asking for, and why they think that they should be entitled to the relief they're seeking.
Judge, you mentioned when we were discussing the trial court that judge is focused on that specific case.
Right.
And that implied that the view at the appellate court level, at least to me, is a little bit broader because you're dealing more with the application of law. Is that right?
Well, it's absolutely right, Locke, and that's such an important distinction because our cases are reported, and they're written down and they're reported in the West law books. So in another similar case, that the facts are saying, the lawyers will cite this case or the decision in this case to support the factual finding in that case. So the appellate courts have to look at not only the justice in this case, but if we say this, how is that going to affect every other similarly situated case? So it's a really important.
It's a huge responsibility.
Responsibility, yes, it is.
And of course, in the real world, those cases guide settlement discussions down at the trial court level, because if the parties can figure out pretty much what's going to happen at the appellate court level, they're going to settle the case.
They certainly can, and and then once we make a decision about a particular factual situation and what the law is under those facts, we're bound by that unless we get together unanimously and overrule that.
Well, and then let's explain to the folks. You talked about how there might be a panel of 3, of 5, of 7, of 9. How does that take place?
What happens is that in a civil case, the trial judge is considered an appellate court judge for appellate purposes, and it takes 3 appellate judges to overrule a civil trial judge. So if the trial judge makes a ruling and 2 out of the 3 appellate judges think the trial judge was wrong, but 1 appellate court judge thinks the trial judge was right,
got a split decision. So
then you got 4-4. So you have to we go get 2 more judges randomly assigned to look at the case, and then it's completely re-argued again.
And the panel of decisions grows larger because of the different positions?
Correct, and because there may be different issues, there may be, in one particular case, may have 4 or 5 different issues on it. So sometime we'll go to a panel of 7, and if it's a very important case, or we want to overrule past First Circuit case law, then all 12 judges will get together and sit and listen and make a determination of whether it should be overruled.
Now, a judge can either agree with the decision, remand it back down, they can reverse the decision, a judge can concur, dissent. Explain what those terms mean.
What that means is that if the judges agree, that means they're in agreement. Sometimes we will agree with the result, but we don't agree with what was written about it, so we will concur. In other words, we think the result's right, but the reasons given we don't quite agree with. But the result was correct. Then sometime we will say reverse, which means we don't agree, and we will render, which means we'll take the record and render a new judgment.
And how many judges out of that panel have to agree to that action?
Depends upon to reverse, and the trial judge, it would take 3 judges for reversal. So we can render, or we can send it back if we feel like a new trial is warranted, or sentencing or something like that. We can send it back to the trial court and have them do that.
Judge, let's talk about, very interesting that it is now being contemplated to put video cameras in the courtrooms. Explain that.
Not video cameras so much, but live video feed. In the Louisiana Supreme Court, over the last 2 years, every oral argument is streamed live via the internet. And you can tune in and watch the lawyers and the justices, the questions they ask. And it's been amazing the great response that has. We are trying to, and I would like to, get a live video feed in every appellate court and every civil district courtroom so that the public could tune in. If you had a trial with Judge X and you wanted to see what a trial with Judge X is like, you don't have to talk to your lawyer so much about it. You can watch Judge X via the internet. Also, openness of the legal system, demystifying, allow people to look, allow people to watch and see what goes on.
Judge, what caused you to contemplate doing this?
Well, there have been some attacks on the judicial system, the Louisiana judicial system, from the U.S. Chamber of Commerce, and says, you know, that we're not so good. And it's based upon hearsay from people who say that they have been in Louisiana courts. Why don't we allow people to see what goes on? We have great judges. We have great lawyers doing good work for people in every courtroom in this state. And why don't we showcase that? Why don't we let people see that and not take somebody else's word for it? Why don't we let the public see?
So what has to happen for that to occur? Does the Supreme Court have to okay it? Or,
yes.
Or can the appellate courts?
That would have to be blessed by the Supreme Court, and we're hoping they will.
And since they're doing it, it sure seems like they will.
We hope so.
Judge, thank you so much for being on the show.
Thank you so much for having me.
It's been great to see you again.
Thank you,
This is
sir.
Locke Meredith with Legal Lines. Judge Duke Welch, First Circuit Court of Appeals, thank you for being with us today.